Please be seated. Good afternoon. The sitting is now open. The court meets this afternoon to hear Tunisia, Vanuatu, the League of Arab States, the Organization of Islamic Cooperation, and the African Union on the questions submitted by the General Assembly. Each of the delegations has been allocated 30 minutes for its presentation. The court will observe a short break after the presentation of the League of Arab States. Je donne à présent la parole.
I now give the floor to the delegation of Tunisia. I call Ms. Hanine Ben-Shrad to the podium. Madam, you have the floor. Mr. President, members of the court, it is an honor for me to appear before your court to state the views of the Tunisian Republic on the request for an advisory opinion currently before the court, which concerns the inalienable right of the Palestinian people to the international relief necessary for their survival as a national group. Tunisia is taking part in these proceedings out of its conviction for the crucial importance of the opinion requested in consolidating the right of the Palestinian people to self-determination and in confirming the central role of the United Nations in delivering the humanitarian and development assistance to the Palestinian people that is necessary for the realization of this right. Tunisia will not hesitate in what follows to set out the obligations of the Zionist entity as an occupying power and as a member of the United Nations. With regard to the presence and activities of the United Nations, other organizations, and third states in and in connection with the occupied Palestinian territory, our statement can in no way be considered as an act of recognition. Tunisia does not recognize the Zionist entity, nor does it maintain relations with it. Nevertheless, the latter is responsible for its actions as an occupying power and for its commitments as a member of the United Nations. Finally, we will outline the legal consequences of systematic disregard of these obligations. As a preliminary point, however, we must show that the court has jurisdiction and that there is no compelling reason justifying the exercise of its discretionary power. Tunisia has no doubt that the court has jurisdiction. The question on which the court is asked to give its opinion is an eminently legal one. It concerns the legal status of the United Nations, other international organizations, and third-party states present in the occupied Palestinian territory, and the obligations, obviously legal obligations, of the Zionist entity arising from them. Under the terms of General Assembly Resolution 79/232, the request for this advisory opinion arises from, and I quote, a difference of opinion between the United Nations and Israel concerning, inter alia, the interpretation or application of the Convention on the Privileges and Immunities of the United Nations, to which Israel is a party, end of quote. A difference of opinion on the interpretation or application of a convention is the very definition of a legal dispute. Moreover, Tunisia sees no compelling reasons for the court to use its discretion not to give this opinion. Firstly, this is not a bilateral question. As such, the possible lack of consent by a party to the conflict cannot render the delivery of the advisory opinion incompatible with the judicial character of the court. Under the terms of General Assembly Resolution 57/107, the question of Palestine is of particular interest and concern to the United Nations, which has to assume a permanent responsibility regarding this question. Secondly, this advisory opinion would have no negative impact on the work of the Security Council. Sorry to interrupt you. Can I please ask you to slow down? Resolution 79/232 was adopted as part of the strengthening of the United Nations system. The Assembly declared that it was gravely concerned about the plans and measures, including laws adopted by Israel, to obstruct or prevent the presence and activities of the United Nations. End of quote. By saying so, the Assembly wanted to preserve, and I quote, the essential role played by the organization in the settlement of conflicts. End of quote. Finally, the question posed by the General Assembly is simple, straightforward, and isn't based on any premise or presupposition. The Court cannot therefore consider, in the exercise of its discretionary power, that this question is biased. Mr. President, members of the Court, in the first part of our presentation, we will examine the Zionist entities' obligations with regard to the presence of the United Nations. We will first analyze the obligations of the Zionist entity as to the presence of the United Nations, other organizations, and third states in the occupied Palestinian territory. And then we will analyze the obligations of the occupying territory with regard to the activities of the organization, other organizations, and third states. There can be no doubt that the legal status of the State of Palestine is that of a state whose territory is occupied. It has the right to exercise full jurisdiction over its territory. Considering that the ineffectiveness of Palestinians' exercise of sovereignty is a direct consequence of the illegal occupation, it in no way affects its statehood. The State of Palestine therefore enjoys the right of passive legation, which is defined as the right of any state to receive the diplomatic representatives of foreign powers, which is subject to mutual consent, in accordance with Article 2 of the Vienna Convention on Diplomatic Relations. The State of Palestine is thus entitled to receive diplomatic representations of states and international organizations on its territory. The occupying authority is obliged to respect this right. The following reasons constitute a breach of this violation. One, on October 29, 2024, the occupying entity passed a law prohibiting the opening of new foreign consulates in Jerusalem. This law is based on the occupying entity's desire to prevent any outside assistance to the Palestinians. These consulates are their only physical link with the rest of the world. Two, the enactment by the Knesset on October 28, 2024 of two laws terminating the activities of UNRWA. These laws technically put an end to the UN agency's activities in the Palestinian territory. Without coordination with the occupying authority, which strictly controls all entry of humanitarian aid consignments and imposes visas on UNRWA staff, it will be almost impossible for the agency to operate in Palestinian territory. These laws also run counter to Article 64, paragraph 2 of the Fourth Vienna Convention that limits the occupying power's capacity to legislate only to those acts that are necessary for the application of the convention. Three, finally, it is important to note that the occupying authority has systematically refused to grant access to United Nations fact-finding missions and to investigators from the International Criminal Court to the occupied Palestinian territory. This refusal deprives victims of any effective remedy and compromises the fight against impunity. In the words of the Secretary General of the United Nations, the occupying entity has been conducting a suffocating occupation of Palestinian territory for decades. As to the UN activities and third parties in occupied Palestinian territories, in its advisory opinion of July 19, 2024, the court noted that, and I quote, the powers and duties of the occupying entity in the occupied Palestinian territory are governed by the Fourth Geneva Convention and by customary international law, and that many of the rules set out therein incorporate obligations which are, in essence, erga omnes in character. In accordance with the normative framework, The occupying entity is bound by the obligation to allow the free passage of humanitarian assistance. It is also bound by the obligation to protect humanitarian operations carried out by relief and civil protection organizations in the occupied Palestinian territory. In accordance with Articles 55 and 56 of the Fourth Geneva Convention, the occupying entity shall ensure that the basic needs of the civilian population are met. If it is unable to do so, it is obliged to accept, under Article 59 of the Fourth Geneva Convention, Article 70, Paragraph 2 of the Additional Protocol 1 to the Fourth Geneva Conventions, it is obliged to accept and facilitate the rapid and unhindered passage of all relief consignments for the benefit of this population. Such action may be undertaken either by states or by an impartial humanitarian organization. It is noteworthy in this regard that the violation by the occupying entity of its intransgressible obligation to allow free access to humanitarian assistance is of a persistent and systematic nature. On October 9, 2023, the occupying entity imposed a complete siege on the Gaza Strip, cutting off essential resources in the movement of goods and severely limiting the population's access to food and water, to fuel and to electricity. Despite the resumption of assistance after October 21, 2023, humanitarian workers have reported that the occupying entity's inspection and control of humanitarian assistance has been slow, incomprehensible, and absurd. These measures have severely impeded the entry of aid trucks, and till the end of September, 83% of food aid has not been able to enter the Gaza Strip. The occupying entity has again imposed a blockade on the enclave since March the 2nd, 2025, starving the population. No truck has entered Gaza since that date. It should be emphasized in this respect that the prolonged blockade of the Gaza Strip imposed by the occupying entity since 2007 meant that half of Gaza's population was already suffering from food insecurity. And the occupying authority knowingly used the obstruction of humanitarian aid as a weapon of war. Several explicit statements by officials of the occupying entity reveal an intention to weaponize humanitarian aid to achieve political and military objectives and to hold the population of Gaza hostage. Some of these statements are undoubtedly indicative of genocidal intent. In August 2024, the occupying entity's Minister of Finance declared that it was, and I quote, justified and moral to starve the entire population of Gaza. As regards the obligation to protect humanitarian action, Article 63 of the Fourth Geneva Convention already granted relief organizations the right to continue their activities under foreign occupation. Article 70 of Additional Protocol 1 stipulates that offers of assistance during armed conflict shall not be regarded as interference or as hostile acts. And in this regard, the court noted what follows. There can be no doubt that the provision of strictly humanitarian aid to persons or forces in another country, whatever their political affiliations or objectives, cannot be regarded as unlawful intervention or as in any other way contrary to international law. Article 63 of Additional Protocol 1 requires the occupying power to grant civil defense organizations the facilities necessary for the accomplishment of their tasks and forbids them to be compelled to carry out their missions in a manner harmful to the interests of the civilian population. And does this protection apply to international organizations operating in occupied Palestinian territory? Article 61 of Additional Protocol 1 defines civil defense as the performance of some or all of the humanitarian tasks intended to protect the civilian population against the dangers of hostilities or disasters, and to help it to recover from their immediate effects, and also to provide the conditions necessary for its survival. This definition is based on the functions performed irrespective of the nature of the entity carrying them out. It follows that any organization, UN or otherwise, authorized by the Palestinian Authority to carry out these humanitarian functions in the occupied Palestinian territory can be considered as a civil defense organization within the meaning of Article 63 of the Additional Protocol 1, as long as its activities pursue the aforementioned objectives. This being said, UNRWA is not a de jure civil defense organization being defined as such only by General Assembly Resolution 302, but it is a de facto one. Numerous violations of this protection have been recorded against international organizations since the outbreak of the war in Gaza. And here are a few examples. The occupying entities' military operations target UNRWA premises almost systematically. Since the beginning of the war in Gaza, 205 UNRWA facilities have been damaged. 273 UNRWA staff members have perished. This is the highest number of deaths ever recorded among UN personnel in a recent conflict. On December 9, 2023, during a high-risk mission to Al-Ahli Hospital, a WHO convoy was inspected at the Wadi Gaza checkpoint. One member of the staff was threatened with a weapon, then harassed, beaten, stripped, and searched. On July 23, 2024, a clearly identified UNICEF vehicle was hit by bullets as it was preparing to pick up 5 young children in order to reunite them with their father after their mother had been killed. On the evening of August 27, 2024, a World Food Programme team came under fire just a few meters from an Israeli checkpoint on the Wadi Gaza bridge. On March 23, 2025, 15 relief workers were killed by Israeli fire in Rafah. Their bodies were found in a mass grave. I will now come to the second part of my presentation pertaining to the failure of Israel to meet its obligations as a member of the United Nations. Mr. President, members of the court, the policies pursued by the occupying entity against any humanitarian or development assistance provided or facilitated by the organization, by other international organizations, or by third states in the occupied Palestinian territory are in violation of its obligations under the Charter and the relevant resolutions of the General Assembly, as well as its obligations under the Convention on the Privileges and Immunities of the United Nations, to which it acceded on September 21st, 1949. As to the obligations of the occupying entity under the Charter, it is clear that the policies are in breach of Article 1 of the Charter concerning the right to self-determination, recognized as inalienable for the Palestinian people by General Assembly Resolution 3236. As to the activities of UN agencies, under the terms of Article 2, Paragraph 5, all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. Other obligations also should be developed. First of all, the obligation to fulfill obligations in good faith. The expression in good faith is it conditions the very status of the members of the United Nations. It says that members can become members if they respect the Charter and are willing to carry out these obligations. Is the occupying entity prepared to fulfill its obligations under the Charter? The answer is, of course, no. The non-respect of the relevant resolution of the UN and the Security Council concerning the aid that is provided and the fact that nothing is done to prevent genocidal acts despite the measures indicated by the court, and these go against the possibility of self-determination of the Palestinian people, and it shows that the occupying entity has constantly breached its obligations under the Charter to fulfill these obligations in good faith. One also needs to develop the obligations under UN resolutions relating to refugees and the right of return. It was created by General Assembly Resolution 302 of December 8, 1949. UNRWA's mission UNRWA was created, therefore, in 1949, and its mission was to assist Palestinian refugees by giving them relief in order to prevent famine and distress among them and to achieve a state of peace and stability. The resolution stipulates that this mission is without prejudice to the provisions of paragraph 11 of Resolution 194.3 on the right of return of Palestinian refugees who fled the 1948-1949 war. All laws and measures taken by the occupying entity against UNRWA's activities in the occupied Palestinian territory constitute a violation of this UN protection to refugees. General Assembly Resolution 2443 of December 1968, which recognizes the essential and inalienable nature of the right of return of Palestinian refugees and links it to the fundamental right to self-determination, as well as the 1951 Convention relating to the status of refugees ratified by the occupying entity on October the 1st, 1954. This being the case, the laws passed against UNRWA based on unsubstantiated allegations and without any supporting evidence, given the agency's exceptional operational performance, conceal, in our opinion, a political will to liquidate the Palestinian refugee question. They constitute further proof of the occupying entity's genocidal intent. We will now examine the obligations of the occupying entity under the Convention on the Privileges and Immunities of the United Nations.
Pursuant to Section 30 of the Convention on the Privileges and Immunities, all differences arising from the interpretation or application of the present Convention shall be referred to the International Court of Justice. The opinion of the Court in this connection, I quote, will be accepted as decisive by the parties. On the 21st of September 1949, the occupying entity acceded without reservation to the Convention on the Privileges and Immunities of the United Nations of the 13th of February 1946. Section 34 of the same convention provides that, I quote, when an instrument of accession is deposited on behalf of any member, the member will be in a position under its own law to give effect to the terms of this convention, unquote. Consequently, domestic law must be in accordance with the convention and allow for its implementation. It follows that the laws ordering cessation of UNRWA's activities have no effect whatsoever on the commitments of the occupying power in terms of the privileges and immunities in relation to the premises and personnel of UNRWA. This is an obligation inherent to its status as a member of the United Nations. Section 35 provides that the Convention shall continue in force between the United Nations and every member which has deposited an instrument of accession for so long as that member remains a member of the organization. Furthermore, the de facto breaches committed by the occupying entity of the Convention on the Privileges and Immunities of the UN are numerous. We have substantiated in the previous sections a number of incidents contrary to Section 3 on the inviolability of the premises of the organization, and Section 18 relating to the immunities of the organization's staff. We should add to that the delay, refusal, or short-term granting of visas to the United Nations staff of the various organizations present in the occupied Palestinian territory, which amounts to a breach of Section 25 of the Convention. We would like to conclude by examining the legal consequences stemming from the violations by the occupying entity of its obligations. The policies and actions carried out by the occupying entity to restrict the presence and the activities of the United Nations Organization, other international organizations, and third states in the occupied Palestinian territory, with a view to preventing them from ensuring, facilitating, and delivering basic supplies essential for the survival of the civilian population of Palestine, as well as of basic services and development aid in the interest of this population, amount to serious breaches of international law. As a result of these violations, first of all, there are legal consequences in terms of serious breaches of obligations erga omnes. These obligations are the ban on the use of force, the breach of the right to self-determination, fundamental rules of international humanitarian law and international human rights law, and the prohibition of genocide. The following consequences stem from the breaches of these obligations. The occupying entity cannot avail itself of legitimate defense or of safety or public order to escape its responsibility or justify its actions. Neither is it entitled to resort to countermeasures. The obligation upon all states to cooperate to put an end to the breaches committed by the occupying entity and to not recognize their legality, the right for all states to invoke the responsibility of the occupying entity and to demand the cessation of these breaches, given that the obligation breached is owed to the international community as a whole. We would stress in this connection that bringing an end to the war will not suffice to make shattered lives whole again or to heal their trauma. The breaches must be reported, as well as the legal consequences stemming from them. Responsibilities must be established. The consequences of the breach of international conventions relating to the privileges and immunities of the Organization of the United Nations and states. The domestic measures and laws adopted which run counter to these international conventions must be considered by all third states and by the organization as unenforceable and worthless. Article 27 of the Vienna Convention on the Law of Treaties of 1969 indeed provides, I quote, that a party may not invoke the provisions of its domestic law in order to justify the non-enforcement of a treaty, unquote. This principle has been codified in Article 32 of the draft articles of the International Law Commission relating to the responsibility of states for internationally wrongful acts. We now come to the consequences of the persistent violation of the principles of the United Nations Charter. While we are aware that the recommendation of relying on Article 6 of the United Nations Charter falls within the prerogatives of the Security Council, we consider that the conditions for its implementations are met. This article provides the following. A member of the United Nations which has persistently violated the principles contained in the present Charter may be expelled from the organization by the General Assembly. In this connection, Tunisia would urge all member states to avail themselves of all the means at their disposal to revert to the spirit of the Charter. Mr. President, members of the Court, I thank you for your attention. I thank the representative of Tunisia for her presentation.
The next participating delegation, Vanuatu, to address the court, and I call upon Mr. Arnold Gill Lachman to take the floor.
Mr. President, distinguished members of the court, it is an honor to appear before you today on behalf of the Republic of Vanuatu in this important advisory proceeding. I am Arnold Kiel-Lofman, Attorney General of Vanuatu. I am joined by Professor Margarita Wawaringe Singh, who will address the court following my remarks. We come before you today compelled by our nation's history, our deep commitment to the principles of UN Charter, and our enduring commitment to the fundamental right of all peoples to self-determination. Like the Palestinian people, Vanuatu understands the vital connection between sovereignty, land, and freedom from colonial and foreign domination. Vanuatu itself is a nation forged in the crucible of colonialism and a determined struggle for independence. We achieved sovereignty relatively recently in 1980 after decades under complex colonial condominium. Our national motto, Long God You May Stand Up, in God We Stand, reflects our reliance on faith and our connection to the land and the waters, the foundation of our identity and survival. This history instills in us a deep empathy and unwavering solidarity with all people still striving to exercise their fundamental right to determination, to determine their own political status and freely pursue their economic, social, and cultural development. Vanuatu's contribution to the present proceedings also stems from our lived reality as a nation on the front lines of the climate crisis. We face an existential threat driven by forces beyond our borders. Climate impacts such as rising sea levels, intensifying cyclones, and various forms of ecosystems degradation are undermining our traditional way of life.
Excuse me, sir. Could you please speak more slowly? Thank you very much.
Thank you, sir. They threaten to render our islands uninhabitable. This experience informs our understanding that the people's connection to their environment, their land, their waters is not merely symbolic. It is existential. It is the bedrock upon which culture, identity, economy, and the very possibility of a self-determined future are built. Before I proceed, let me express Vanuatu's alignment with the vast majority of participants on core issues raised in this proceeding. The general applicability of international humanitarian law, including Hague Regulation of 1907 and the Fourth Geneva Convention of 1949, and the international human rights law to the occupied Palestinian territories, is beyond question. Israel, as the occupying power and a member of UN, bears specific obligation under these regimes to ensure the welfare of the protected population and to facilitate, not hinder humanitarian access and assistance provided by the UN and its agencies, other international organizations, and third states. This requires an immediate end to the bombardments, incursions, and blockade of Gaza. The obligations concerning the provisions of essential supplies like food, water, medicine, and shelter, and basic services like healthcare and sanitation are clear and non-derogable. To avoid repetition and contribute most effectively to the court's deliberations, Vanuatu seeks to focus its detailed submission on a specific yet fundamental element of the question posed, the right to self-determination and its ecological dimension. As many participants noted, the Palestinian people's right to self-determination is central to the legal question before us. This right is not an abstract concept. It is exercised by a people in relation to a territory and its resources. Destroying or degrading the Palestinian environment is tantamount to destroying the material basis upon which Palestinian self-determination can be built and sustained. This is particularly pertinent in the context of relentless bombardments, incursions, water shortage, toxicity, and deliberate withholding of life-sustaining necessities. Mr. President, Madam Vice President, the facts reveal a pattern of severe and escalating environmental degradation directly linked to the conduct of the occupying power. First, the record shows that over 1.9 million Palestinians in Gaza alone have been repeatedly uprooted, in many cases refugees for a second or third time, through bombardment, starvation, and forcible transfer policies announced at the highest level of the occupying power. Each such displacement separates a people from the soil and sustains them. Ancient olive terraces, barley dry farming plots, and coastal aquifers. Second, UN reports consistently highlight the contamination and depletion of water sources in Gaza, exacerbated by the destruction of desalination plants, wells, and sewage infrastructure. Across the OBT, restrictions on access to water and the control over water resources violate fundamental rights, such as those to health, food, and water itself. Vast swaths of agricultural land, crucial for Palestinian food security, have been damaged or destroyed by military operations, infrastructure projects associated with settlements, and restrictions on access. These include the raising of olive groves, which hold deep cultural and economic significance. These are not collateral mishaps. They are patterns of slow and fast ecological violence that, in the words of the Women's International League for Peace and Freedom, amount to the ecocide of Palestine. Military violence forms a distinct part of this onslaught. The destruction of infrastructure generates enormous quantities of debris, often containing hazardous materials like asbestos and unexploded ordnance. The collapse of waste management system caused severe health impacts and long-term soil and water contamination. Munitions residue further contaminates ecosystems. Coastal ecosystems, terrestrial habitats, and biodiversity are inevitably impacted by conflict, pollution, and land degradation, further diminishing the natural heritage available to the Palestinian people. The attacks on Palestinian ecosystem have profound direct consequences for the Palestinian civilian population, impacting their health, food security, livelihood, and cultural connection to the land, and leading to further displacement, aggravating the violation of Palestinian refugees' right to return. These human impacts are not uniform. They disproportionately affect women, children, farmers, and fishers, the elderly, persons with disabilities, and other disadvantaged groups. Cumulatively, these impacts severely undermine the prospects for sustainable development and the exercise of self-determination by both present and future generations of Palestinians. Mr. President, the activities of the United Nations, including UNRWA, and those of other international organizations and third states are crucial, not only for immediate humanitarian relief, but also for assessing, mitigating, and repairing this environmental damage. They play a vital role in providing safe water, restoring sanitation, supporting sustainable agriculture, clearing rubble, and planning for long-term environmental rehabilitation. Therefore, Israel's obligation, as queried by the General Assembly, must encompass ensuring unhindered access and activities related to Palestinian-led environmental stewardship and rehabilitation. Continuing life-destroying hostilities, blocking the import of necessary equipment for water purification or waste management, or preventing access to damaged agricultural land for rehabilitation contravenes these obligations. The right to self-determination reinforces these obligations, bearing in mind that the environmental viability of the OPT is inextricably linked to the survival and future of the Palestinian people. The obligation at stake in these proceedings must therefore be interpreted and applied in a manner that recognizes and protects this vital connection. As indigenous people around the world understand all too well, for Palestinians, land is not merely property, but the very source of life, and its destruction goes to the heart of the prospect of a sustainable future. Mr. President, these considerations lead directly to the legal arguments concerning the nature and scope of the relevant obligations, which Professor Wawiringa-Singh will now elaborate upon. I thank you, Mr. President, and distinguished members of the court for your attention, and I'll ask you to invite Professor Wawiringa-Singh to continue Vanuatu's submission.
I thank Mr. Rahman. I now invite Professor Margareta Wawiringa-Singh to address the court. You have the floor, madam.
Mr. President, Madam Vice President, distinguished members of the court. It is an honor to follow the Attorney General of Vanuatu and to present the second part of Vanuatu's oral statement. My submissions will unfold as follows. I will first address the legal character of the right to self-determination, including its jus cogens status, and the implications thereof. Second, I will elaborate on the normative content of this right, submitting that it necessarily includes an ecological dimension with correlating obligations. Third, I will set out the legal consequences of breaches of these obligations. I will conclude by outlining how these primary and secondary obligations directly inform the answer to the question posed by the General Assembly and suggest specific points for the court's clarification. Mr. President, Madam Vice President, members of the court. The right to self-determination forms a central part of the question posed by the General Assembly, as many before us have highlighted. And it is particularly important to the answer. First, its jus cogens status means that the right permits no derogation. Obligations flowing from it cannot be set aside by treaty or acquiescence. Second, it has interpretive implications. It requires that every treaty provision, every rule of custom, every general principle of law applicable must be interpreted to safeguard the Palestinian people's ability to exist on and with their land. Also, in practice, as this court has emphasized, the right to self-determination, and I quote, cannot be subject to conditions, end quote. Third, the right to self-determination generates obligations erga omnes, meaning that all states and international organizations have a legal interest in its realization. This brings me to the fourth point, which concerns legal consequences. This point requires a bit more elaboration. Many before us already highlighted this court's finding that Israel's unlawful policies and practices in the occupied Palestinian territory violate the Palestinian people's right to self-determination. A violation which, as the court indicated, is aggravated by its prolonged character. The court also elaborated legal consequences attaching to this breach for the international community as a whole. The references in Resolution 79/232 to this opinion and to the right to self-determination, including in the question itself, clearly signal that these legal consequences are intertwined with the obligations the court has been asked to clarify. As Counsel for Palestine argued, dissociating these secondary obligations from primary obligations would be artificial. Both are part of the system of international responsibility. The question's focus on the obligations of Israel does not suggest otherwise, as these obligations are relational, that is, I quote, in relation to the presence and activities, end quote, of the United Nations, other international organizations, and third states. Mr. President, Madam Vice President, members of the court, answering the question thus requires a reality check, one that is not just factual, what is the law in the face of atrocities, but also deeply normative. What is the law in a context of persistent, progressively aggravated violations of jus cogens norms? The inseparability of primary and secondary norms has seldom been so clearly illustrated as in the present case. Here, imposing a firm separation between the two categories would create a type of alternative law, completely detached, not just from the real world and the facts before us, but from the normative reality of international law. For even an undergraduate student of international law will know that a breach of international obligations entails legal consequences, which arise automatically and as a matter of hard, indisputably binding law. They do not evaporate following a court's pronouncement on their existence. They remain real and binding for as long as the breach continues, shaping the legal relationships referenced in the question and demanding integration into the answer. Mr. President, members of the court, Vanuatu submits that the right to self-determination inherently encompasses an ecological dimension, which gains a specific meaning in the context of occupation. This dimension is rooted in each of the 4 elements of self-determination identified in the court's 2024 opinion. Territorial integrity is violated where the territory itself is turned into ecological ruin. Environmental displacement undermines the integrity of the Palestinians as a people, altering demographics and severing relationships to their land and water. The right to exercise permanent sovereignty over natural resources is violated where those resources are destroyed, depleted, or rendered unusable. Likewise, a people cannot freely determine their political status and pursue their economic, social, and cultural development when their land is ruined. A key point here is that the Palestinian people's relationship to their land and natural resources is not simply a political or economic calculation, but part of their culture and identity as a people, and thus must be protected as an essential ecological dimension of their self-determination. Accordingly, Vanuatu contends that the obligation to support the Palestinian people's right to self-determination entails a distinct obligation to respect and help restore their historic relationship with the land. Israel's duties as a UN member state, including under Article 56 of the UN Charter, reinforce this obligation. Further, international humanitarian law offers relevant safeguards that must be respected in partial fulfillment of this obligation. In particular, Article 55 of the Hague Regulations of 1907 obliges the occupying power to safeguard the capital of natural resources for the people under occupation. Any destruction or wasteful or negligent exploitation of land, water, or biodiversity by the occupying power constitutes a breach of that obligation. Articles 53, 55, and 56 of the Fourth Geneva Convention require protection of property indispensable to civilian survival. In Vanuatu's submission, this includes soil, aquifers, and sanitation systems. Equally relevant is the obligation to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, including essential supplies and basic services. This rule must be interpreted to include ensuring safe and unhindered access for personal and equipment needed for water purification and sanitation, for environmental health monitoring and response, assessment and cleanup of pollution and hazardous waste, support for sustainable agriculture and rehabilitation of damaged land, and monitoring and protection of biodiversity and natural resources. As Bolivia and others have noted, these obligations go to the heart of the law of state responsibility. They are not merely primary obligations of Israel, but concern attempts by members of the international community to discharge their own obligations to end or at least mitigate serious breaches of Uskogan's norms. International human rights law applies concurrently and enshrines rights to life, health, food, water, and culture, each contingent on a clean, healthy, and sustainable environment, itself a universal right inseparable from self-determination. Actions that cause severe environmental degradation breach a range of erga omnes obligations arising from these rights and from the right to self-determination. Mr. President, Madam Vice President, members of the Court, international human rights law demands particular attention for the intersectional dimension Also, in practice, as this court has emphasized, the right to self-determination, and I quote, cannot be subject to conditions, end quote. Third, the right to self-determination generates obligations erga omnes, meaning that all states and international organizations have a legal interest in its realization. This brings me to the fourth point, which concerns legal consequences. This point requires a bit more elaboration. Many before us already highlighted this court's finding that Israel's unlawful policies and practices in the occupied Palestinian territory violate the Palestinian people's right to self-determination. A violation which, as the court indicated, is aggravated by its prolonged character. The court also elaborated legal consequences attaching to this breach for the international community as a whole. The references in Resolution 79/232 to this opinion and to the right to self-determination, including in the question itself, clearly signal that these legal consequences are intertwined with the obligations the court has been asked to clarify. As Counsel for Palestine argued, dissociating these secondary obligations from primary obligations would be artificial. Both are part of the system of international responsibility. The question's focus on the obligations of Israel does not suggest otherwise, as these obligations are relational, that is, I quote, in relation to the presence and activities, end quote, of the United Nations, other international organizations and third states. Mr. President, Madam Vice President, members of the court, answering the question thus requires a reality check, one that is not just factual, what is the law in the face of atrocities, but also deeply normative. What is the law in a context of persistent, progressively aggravated violations of Jus Cogens norms? The inseparability of primary and secondary norms has seldom been so clearly illustrated as in the present case. Here, imposing a firm separation between the two categories would create a type of alternative law, completely detached, not just from the real world and the facts before us, but from the normative reality of international law. For even an undergraduate student of international law will know that a breach of international obligations entails legal consequences, which arise automatically and as a matter of hard, indisputably binding law. They do not evaporate following a court's pronouncement on their existence. They remain real and binding for as long as the breach continues, shaping the legal relationships referenced in the question and demanding integration into the answer. Mr. President, members of the court, Vanuatu submits that the right to self-determination inherently encompasses an ecological dimension, which gains a specific meaning in the context of occupation. This dimension is rooted in each of the four elements of self-determination identified in the court's 2024 opinion. Territorial integrity is violated where the territory itself is turned into ecological ruin. Environmental displacement undermines the integrity of the Palestinians as a people, altering demographics and severing relationships to their land and water. The right to exercise permanent sovereignty over natural resources is violated where those resources are destroyed, depleted, or rendered unusable. Likewise, a people cannot freely determine their political status and pursue their economic, social, and cultural development when their land is ruined. A key point here is that the Palestinian people's relationship to their land and natural resources is not simply a political or economic calculation, but part of their culture and identity as a people, and thus must be protected as an essential ecological dimension of their self-determination. Accordingly, Vanuatu contends that the obligation to support the Palestinian people's right to self-determination entails a distinct obligation to respect and help restore their historic relationship with the land. Israel's duties as a UN member state, including under Article 56 of the UN Charter, reinforce this obligation. Further, international humanitarian law offers relevant safeguards that must be respected in partial fulfillment of this obligation. In particular, Article 55 of the Hague Regulations of 1907 obliges the occupying power to safeguard the capital of natural resources for the people under occupation. Any destruction or wasteful or negligent exploitation of land, water, or biodiversity by the occupying power constitutes a breach of that obligation. Articles 53, 55, and 56 of the Fourth Geneva Convention require protection of property indispensable to civilian survival. In Vanuatu's submission, this includes soil, aquifers, and sanitation systems. Equally relevant is the obligation to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, including essential supplies and basic services. This rule must be interpreted to include ensuring safe and unhindered access for personnel and equipment needed for water purification and sanitation, for environmental health monitoring and response, assessment and cleanup of pollution and hazardous waste, support for sustainable agriculture and rehabilitation of damaged land, and monitoring and protection of biodiversity and natural resources. As Bolivia and others have noted, these obligations go to the heart of the law of state responsibility. They are not merely primary obligations of Israel, but concern attempts by members of the international community to discharge their own obligations to end or at least mitigate serious breaches of Iskogan's norms. International human rights law applies concurrently and enshrines rights to life, health, food, water, and culture, each contingent on a clean, healthy, and sustainable environment, itself a universal right inseparable from self-determination. Actions that cause severe environmental degradation breach a range of erga omnes obligations arising from these rights and from the right to self-determination. Mr. President, Madam Vice President, members of the court, international human rights law demands particular attention for the intersectional dimensions of ecological harm. Environmental destruction strikes vulnerable or marginalized groups with particular force. Pregnant women who are forced to give birth in inhumane and unsafe conditions, absent clean water. Children who survive atrocities may die of exposure to toxins or famine, detached from their ancient cultural heritage of food sovereignty and reciprocity with the land. Elders can no longer pass on these traditions where they and the land are met with unspeakable violence and destruction. These intersectional impacts not only reveal human rights violations, but also an existential threat to the Palestinian people as a whole, violating their right to self-determination. Moreover, they aggravate the ongoing breach of Article 3 of CERD, established by this court in its 2024 opinion. the intergenerational impacts of ecological harm require specific normative attention. On this point, Vanuatu submits that the principle of intergenerational equity, demanding that present actions do not compromise the ability of future generations to meet their own needs and exercise their rights, is applicable as a general principle of law that informs the content of self-determination. Contaminating aquifers, destroying fertile soil, decimating ancient olive groves. These actions constitute serious breaches of the right to self-determination, as they deny future generations of Palestinians the resources and healthy environment necessary to build a sustainable society and exercise their own right to self-determination. Finally, the obligation to promote the Palestinian people's right to self-determination implies a positive duty to cooperate with international efforts aimed at preserving the environmental basis for that right on the Palestinian people's terms. Hindering these efforts breaches obligations not only under specific rules regarding relief, but also under the Jus Cogens norm of self-determination. Here also, the relevant obligations include secondary obligations aimed at ending the ongoing, prolonged breaches identified previously by this court. Mr. President, Madam Vice President, members of the court, the law of state responsibility is an indispensable part of the applicable law in the present proceedings. Allow me to briefly highlight the legal consequences relating directly to ecological integrity and self-determination. For Israel, cessation of the serious breach of the right to self-determination, including its ecological dimension, entails first and foremost an immediate end to the hostilities and working in good faith towards lasting peace in the region. Vanuatu calls on the court to articulate this duty of cessation in the clearest possible terms, thus safeguarding international law's integrity and leaving no ambiguities to be exploited as a pretext for the continuation of this serious breach. Naturally, cessation also requires restoring compliance with the full range of its international obligations protecting the Palestinian people and their territory, including obligations to facilitate and support the work of the UN, including UNRWA, acknowledged by the Security Council as the backbone of all humanitarian response in Gaza and irreplaceable in terms of capacity and mandate, as well as that of other international organizations and third states. Israel must make full reparation for the injury caused, including support for Palestinian-led ecological restoration and guarantee non-repetition. The promise embedded in reparation is captured in the work of Palestinian poet Fatba Tukan, who wrote in 1967, I quote, "When the fallen tree rises up, the branches shall flourish, green and fresh in the sun, and birds shall return." End quote. For all other states and international organizations, the legal consequences include non-recognition of the illegal situation created by environmental destruction, annexation, and forced displacement, not rendering any aid or assistance that would maintain that situation, such as licensing extractive companies or supplying equipment, including weapons, that enables environmental destruction, and cooperating, including through sanctions, embargoes, or other lawful countermeasures to bring the serious breach to an end. The United Nations must urgently consider modalities, economic, political or otherwise, to secure compliance if Israel persists. Mr. President, Madam Vice President, allow me to summarize Vanuatu's submissions. Environmental degradation, driven or exacerbated by the occupation, military assaults, and violations of obligations relating to relief and cooperation, directly threatens the survival of the Palestinian people. It undermines the very possibility of a viable, sustainable future in which the Palestinian people's right to self-determination can be meaningfully exercised. Vanuatu respectfully invites the court to acknowledge the same in the opinion and to clarify the following 5 points. First, that the Palestinian people's right to self-determination encompasses a duty to respect the Palestinian people's reciprocal relationship with their land and to safeguard the ecological integrity of their territory. Second, that Israel's obligations as occupying power include facilitation of international organizations and third state activities aimed at ecological assessment and rehabilitation. Third, that persistent environmental degradation combined with mass displacement constitutes a grave breach of the Jus Cogens right to self-determination, engaging Israel's aggravated responsibility and triggering erga omnes obligations for all states and international organizations, including concerted action for cessation and reparation. Fourth, that the duties of other states extend to refraining from trade, investment, or military cooperation that contributes directly or indirectly to ecological harm in the occupied Palestinian territory. And fifth, that the court's clarification should guide the General Assembly, Security Council, and states in adopting measures proportionate to the gravity of the breach. Mr. President, Madam Vice President, distinguished members of the court, this concludes Vanuatu's submissions. I thank you for your careful attention.
I thank the representatives of Vanuatu for their presentation. I now invite the delegation of the League of Arab States to address the court, and I call upon Professor Mohammed Helal to take the floor.
Mr. President, Madam Vice President, members of the court, it is an honor to appear before you on behalf of the League of Arab States. And with your permission, I shall address the following 3 issues in our pleadings. First, Israel's obligations in relation to the presence and activities in the OPT of UNRWA, other UN bodies, other international organizations, and third states. Second, Israel's obligations to provide humanitarian relief and supplies essential to the survival of the Palestinian civilian population. And third, Israel's obligations relating to the Palestinian people's right to self-determination. Mr. President, before addressing these issues, I shall highlight 4 preliminary points. First, the Arab League respectfully submits that in addressing the question before it, the court should be guided by 2 core considerations. These are, first, the permanent responsibility of the UN for the question of Palestine, and second, the legal obligation of all states to support the right of self-determination of the Palestinian people. The activities of the UN in the OPT are not merely humanitarian operations that provide relief for a population living under occupation. Rather, the activities of UNICEF, UN Women, UNRWA, OCHA, and other UN entities in the OPT are a manifestation of the UN's permanent responsibility to promote the welfare of the Palestinians until the question of Palestine is justly and comprehensively resolved in accordance with international legitimacy. Moreover, assistance programs by third states and international organizations are not acts of charity for the benefit of a dispossessed people. Rather, humanitarian assistance and development programs and efforts such as the establishment of diplomatic relations with the state of Palestine are acts that uphold the duty incumbent on all states to take joint and separate action to support the right of self-determination of the Palestinians. Therefore, in answering the question before it, the court should not limit itself to applying specific regimes such as occupation law or UN privileges and immunities, but it should assess Israel's obligations and conduct against the backdrop of its duty not to obstruct the UN's discharge of its permanent responsibility for the question of Palestine, and its duty not to undermine efforts by third states and international organizations to support the self-determination of the Palestinian people. Second, Israel has no sovereign authority over, nor can it exercise sovereign powers in the OPT, including East Jerusalem. Accordingly, Israeli legislative or administrative measures that entail the exercise of sovereign authority or powers in the OPT are unlawful. This applies to measures adopted in relation to UNRWA on October 28, 2024. Third, contrary to Israel's written statement, sovereignty over the West Bank is not in abeyance. Sovereignty over the entire OPT is vested with the Palestinian people. Moreover, as Judge Gomez Robledo stated, the existence of the Palestinian state should not be called into question, and neither should the possibility for it to be admitted as a full member state of the United Nations, end quote. Accordingly, the Arab League respectfully submits that the court should take cognizance of the fact that the state of Palestine, the legitimate representative of the Palestinian people, has concluded agreements with the UN regarding the operation of its agencies and bodies. We also concur with the Secretary General that Israel must respect these decisions of the representative of the Palestinian people. Fourth, there is no jurisprudential justification to limit the scope of the court's opinion to Israel's obligations under primary rules of international law. The term obligations in the question referred to the court should be given its ordinary meaning. It encompasses obligations under both primary and secondary rules relating to consequences arising from internationally wrongful conduct. We respectfully submit that the court should opine on Israel's obligations that arise from the rules of state responsibility and that relate to Israel's wrongful conduct in respect of the operations of the UN, third states, and other international organizations in the OPT. These obligations include the duty to cease wrongful conduct, the duty to guarantee non-repetition, and the duty to provide reparation for injuries caused by wrongful conduct. Mr. President, I shall now turn to Israel's obligations with respect to UNRWA. Many parties have already underscored UNRWA's indispensable role in the life of Palestine refugees. The applicability of UN privileges and immunities to UNRWA has also been emphasized by many participants. Therefore, I shall focus on UNRWA's mandate that makes it crucial for the discharge of the UN's permanent responsibility for the question of Palestine. UNRWA is much more than a relief agency. UNRWA is the principal instrument by which the UN protects the right of return of Palestine refugees. It is not an exaggeration to argue that preserving the right of return is the agency's raison d'etre. This is reflected in that General Assembly Resolution 302 that established UNRWA, cited paragraph 11 of General Assembly Resolution 194, which recognized the right of return of Palestine refugees. Subsequent resolutions renewing UNRWA's mandate reaffirmed paragraph 11 of Resolution 194, which confirms that the General Assembly recognizes that the principal objective of UNRWA is preserving the right of return. In addition to being a fundamental right of Palestine refugees, preserving the right of return is essential to protecting the right of self-determination. And the reason is simple. If Palestine refugees are denied their right of return, and if they are further displaced, dispersed, and dispossessed, the ability of the Palestinian people to exercise self-determination would be forever lost. And that is why UNRWA is indispensable. For decades, it has preserved the integrity of the Palestinians as a people. It prevented their dispersal and forced displacement, and it ensured that they remain on the territory in relation to which they are entitled to exercise self-determination. Furthermore, UNRWA is part of a legal and institutional regime that specifically protects Palestine refugees. This is reflected in Article 1D of the 1951 Refugee Convention, which excludes Palestine refugees from the protective mandate of the UN High Commissioner for Refugees. Accordingly, the Arab League submits that Israel is under an obligation not to obstruct UNRWA's work. This obligation is based inter alia on Article 2, Paragraph 2, and Article 2, Paragraph 5 of the Charter, and on Israel's obligation not to obstruct the UN's discharge of its permanent responsibility for the question of Palestine and its broader duty to respect the right of self-determination. These obligations are complemented by further undertakings by Israel. On May 6, 1949, during debates on Israel's admission to the United Nations, Israel's representative, Mr. Abba Eban, stated, quote, "We shall cooperate with organs of the United Nations with all the means at our disposal in the fulfillment of the part of the resolution concerning refugees." Israel also assured the General Assembly that, quote, "The settlement of frontiers, the internationalization of Jerusalem, and the Arab refugee problem would not be regarded as within the domestic jurisdiction of Israel," end quote. These statements constitute unilateral declarations that created legal obligations for Israel in relation to the right of return of Palestine refugees. Mr. President, I shall now turn to Israel's obligations in respect of other UN bodies and other third parties operating in the OPT. And again, instead of repeating arguments made by other parties, I shall address claims raised by Israel in its written statement and arguments made by other parties in their oral statements, especially relating to the applicable law and the content of Israel's obligations under humanitarian law. I will begin with the legal status of and the law applicable to the Gaza Strip. Israel contends that as relates to the Gaza Strip, quote, "It is the law of armed conflict and in particular, the law on conduct of hostilities, which applies. This is incorrect. First, civilians are generally entitled to the protections enshrined in the Fourth Geneva Convention whenever they find themselves in the hands of a hostile power. The commentary on Article 6 of the Fourth Geneva Convention is unequivocal. Quote, "The relations between the civilian population of a territory and troops advancing into that territory, whether fighting or not, are governed by the present convention. There is no intermediate period between what might be termed the invasion phase and the inauguration of a stable regime of occupation. No loophole is left," end quote. Second, it is a fact that Gaza is subject to Israel's belligerent occupation. According to judicial precedent, occupation exists whenever a hostile power exercises effective control over a territory. Now, applying the factual criteria elaborated in these precedents confirms that the Gaza Strip, like the West Bank and East Jerusalem, has been under occupation since 1967 and is subject to Israel's occupation today. This means that Section 3 of Part 3 of the Fourth Geneva Convention on Belligerent Occupation is applicable to the entire OPT, alongside other customary humanitarian law rules, including those found in the first additional protocol. Israel has also stated that generally, quote, "the responsibility of an occupying power is coupled with authority," end quote. It also cited Article 43 of the Hague Regulations and Article 64 of the Fourth Geneva Convention and argues that, quote, "neither of these provisions impose any duties on the occupying power vis-a-vis third parties, nor do they create any rights for them." Israel also suggests that an occupying power has, quote, "the authority and power to determine whether, when, and to what extent third parties may be present and operate in the occupied territory," end quote. These arguments by Israel misrepresent an occupying power's obligations. To further explain, I will begin with Article 64 of the Fourth Geneva Convention. This provision does not grant an occupying power a carte blanche to administer an occupied territory as it sees fit. The commentary to Article 64 confirms that, quote, "an occupying power is to respect the laws in force in the country unless absolutely prevented," end quote. The commentary also explains that restrictive measures applied by an occupying power, quote, "must not, under any circumstances, serve as a means of oppressing the population. The legislative and penal jurisdiction exercised by occupation authorities as holder of public power is therefore hedged about with numerous safeguards," end quote. These safeguards arise inter alia from the following obligations. First, given that the population in the OPT is inadequately supplied, Article 59 of the Fourth Geneva Convention obligates Israel to agree to relief schemes for the population. In its oral statement, the United States suggested that under Article 59 and other provisions, quote, "an occupying power retains a margin of appreciation concerning which relief schemes to permit. And even if an organization offering relief is an impartial humanitarian organization, and even if it is a major actor, occupation law does not require an occupying power to allow and facilitate that specific actor's relief operations, end quote. Respectfully, we do not share this interpretation of Article 59. The commentary to the Fourth Geneva Convention states unequivocally that the obligation to accept relief schemes is, quote, unconditional. This is confirmed by the terms of Article 55, which states that an occupying power shall agree to, shall facilitate, and shall permit relief schemes. Moreover, the phrase may be undertaken in the second paragraph of Article 59 does not broaden the discretion of an occupying power. Rather, occupying powers, quote, have no latitude to withhold consent to relief schemes by impartial humanitarian organizations which can lend assistance to the population. It was also argued that an occupying power, quote, may still impose restrictive measures for urgent reasons of security. Again, the Arab League underscores that the discretion or margin of appreciation is severely restricted. The commentary to the Fourth Geneva Convention, again, is clear. Not only must an occupying power agree to relief schemes, but it must, quote, cooperate wholeheartedly in the rapid and scrupulous execution of these schemes, end quote. Second, Israel is bound by customary obligations in the first additional protocol, especially Articles 68 to 71. Cumulatively, these provisions require Israel to allow and facilitate the rapid and unimpeded passage and distribution of humanitarian aid and to assist relief missions to the fullest extent practicable. Third, in terms of the content of relief schemes, Israel must uphold the customary rules found in Article 69 of the First Additional Protocol, which supplements Article 55 of the Fourth Geneva Convention. This requires Israel to provide all essential supplies, including food, medicine, clothing, bedding, shelter, and fuel for heating purposes. The commentary to the First Additional Protocol is clear. This obligation is, quote, a positive, complete requirement. Fourth, Israel must respect and guarantee the safety of personnel involved in relief actions. This obligation arises from Articles 59 and 60 of the Fourth Geneva Convention and customary rules codified in the First Additional Protocol, including the protections afforded to civilians and civilian objects in Articles 48 and 52 of the First Additional Protocol. Now, in addition to these rules of humanitarian law, Israel has obligations that apply specifically to the UN. These obligations are found in the rules on UN privileges and immunities, which are codified inter alia in Article 105 of the Charter and the General Convention. The written statement and oral pleadings of the Secretary General have already elaborated on the content of these obligations. Therefore, I shall only underscore that UN privileges and immunities provide an elevated level of protection to UN agencies, bodies, premises, and personnel. These rules, especially the immunity of the UN from legal processes and the inviolability of UN premises, property, and assets, are absolute and mandatory. These rules admit no exceptions in cases of armed conflict. Moreover, structurally, the rules of UN privileges and immunities form a system that includes substantive provisions on facilities, privileges, and immunities accorded to the UN, and it also establishes, pursuant to Article 5, Section 21, and Article 8, Section 30, an efficacious procedural mechanism to address alleged abuses of these rules. This merits viewing this system of rules in terms similar to those employed by the court in the Tehran hostages case to characterize the regime of rules of diplomatic law. Accordingly, we submit that the court should determine that Israel has an obligation not to take unilateral actions against the UN, and that Israel should avail itself in relation to any concerns about abuses of UN privileges and immunities. It should avail itself of avenues to address these matters provided in the General Convention and other mechanisms available at the UN. Mr. President, I shall now address Israel's obligation to provide humanitarian relief to the Palestinian population. In this regard, I respectfully draw the court's attention to an opinion authored by 9 leading Israeli jurists who affirmed that Israel is under a positive obligation to, quote, actively ensure that the local population has sufficient access to the supplies needed for survival. These positive obligations are a special case of the more general obligation under the laws of belligerent occupation to ensure public order. The presence of international organizations, including the UN, in the area does not relieve the occupying power of this duty, end quote. These obligations are supplemented by Article 49 of the 4th Geneva Convention that prohibits forcible transfer or deportation, and Article 54 of the 1st Additional Protocol that protects objects indispensable for the survival of the civilian population. These obligations are pertinent because Israel is creating conditions calculated to cause the forced displacement of the Palestinian people by weaponizing humanitarian assistance and obstructing relief schemes. Mr. President, I shall now briefly address Israel's obligations that arise from the right to self-determination. The court has already affirmed that Israel's presence in the OPT violates the obligation, Israel's obligation, to respect the right of the Palestinian people to self-determination. The court also outlined consequences arising from that wrongful act. The present proceedings invite the court to go a step further. The court is requested to clarify Israel's obligations in respect of joint and separate action taken in support of the right of self-determination of the Palestinian people. And in addressing this question, the point of departure should be Vice President Sebutendi's observation, quote, without the right to self-determination, the entire international legal order would crumble. It is a bedrock principle on which so many rights that the international community holds dear are built, end quote. Furthermore, as Judge Iwasawa explained, quote, the paramount importance of the principle of self-determination is reflected in its erga omnes character, in the sense that it not only confers a right on peoples to self-determination, but also imposes an obligation on all states to see to it that this right is respected. Because of its peremptory status, all states must bring to an end serious breaches of this fundamental right. In this regard, the ILC indicated that, quote, where an international organization has discretion to act, the obligation to cooperate imposes a duty on the members of that international organization to act with a view to the organization exercising that discretion in a manner to bring an end to the breach of a peremptory norm, end quote. We submit that Israel is duty-bound not to obstruct joint and separate action to promote the right to self-determination, whether taken collectively through international organizations or individually by states. This is consistent with the 1970 Friendly Relations Declaration. that imposes the obligation to, quote, render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle of self-determination. Mr. President, Madam Vice President, members of the court, I cannot conclude the pleadings of the Arab League without recalling that the tragedy of Palestine is seared into the hearts, minds, and collective memory of 450 million Arabs. Palestine is the core cause of the Arabs. The decades of dispossession and countless crimes committed against the Palestinians have led us to wonder whether the people of Palestine are less deserving of compassion, less worthy of empathy, less entitled to justice, or simply less human. The plight of Palestine challenges the proposition that humanity is a community bound by common values. To address this continuing tragedy, we have offered a vision of peace and prosperity for our troubled region. Our overtures of peace, including the 2002 Arab Peace Initiative, envision a future of a free and independent state of Palestine living alongside Israel under international law. But Israel has consistently failed to seize this opportunity for peace. Israel's political leadership has shown that it is not a credible partner for peace. Indeed, Israel has now launched an offensive against the UN, civil society, and other states that have been moved to aid the Palestinians out of a realization that never again is now, and that history will neither forgive nor forget those who stood aside as Israel's onslaught continues to unfold in Gaza and throughout the OPT. The question of Palestine is a litmus test for international law and the institutions that uphold it. But despite the desperation that is often felt about the efficacy of international law, we are both hopeful and confident that the court will once again uphold the rights of the Palestinian people and exhort Israel to live up to its international obligations. Mr. President, that concludes the statement of the League of Arab States, and I thank you for your attention.
I thank the representative of the League of Arab States for his presentation. Before I invite the next delegation to take the floor, the court will observe a break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, the Organisation of Islamic Cooperation, to address the court, and I call His Excellency Ambassador Samir Birka to the podium. You have the floor, sir.
Mr. President, distinguished members of the court, I have the honor of appearing before you on behalf of the Organization of Islamic Cooperation to express the confidence we place in your High Court so that through the advisory opinion requested you may enlighten the General Assembly in its task. The Organization of Islamic Cooperation comprises 57 member states and is the collective voice of the Muslim world. This intergovernmental organization was created following the arson attack on the Al-Aqsa Mosque in Jerusalem in 1969. The charter of our organization includes among its objectives our support for the right of the Palestinian people to self-determination and to establish their own sovereign state with Al-Quds Sharif, East Jerusalem, as its capital. This means that our organization is particularly attentive to the just struggle of the Palestinian people and is deeply concerned by the ongoing aggression being waged by Israel, the occupying power, against the Palestinian people in Gaza and the West Bank, including East Jerusalem. The vital risk posed to them by Israel's operations and the worsening situation caused by Israel's unfounded closure of UNRWA offices. Our organization therefore held an extraordinary session of the Council of Ministers of Foreign Affairs of member states in Jeddah, Kingdom of Saudi Arabia, on 7th March 2025. In view of the gravity of the situation, we insisted on the need to compel Israel, the illegal occupying power, to implement a permanent and comprehensive cessation of its aggression, the facilitation of the return of displaced persons to their homes, the withdrawal of Israeli occupying forces, opening of all crossing points, and the guarantee of adequate delivery of humanitarian aid throughout the Gaza Strip, in compliance with its obligations under international law, international humanitarian law, and relevant United Nations resolutions. We have denounced the policies of famine and scorched earth that are designed to force the Palestinian people out of their homeland. And we have rejected any Israeli attempt to alter the demographic composition of the Palestinian people, of the Palestinian territory. In the face of recent measures taken by Israel, the occupying power, against activities carried out in the occupied Palestinian territory by United Nations bodies, we have reiterated our rejection of all Israeli measures, including racist and illegal laws targeting the very existence of UNRWA, a United Nations mandated agency, and attempts to restrict or abolish its irreplaceable role in the West Bank, including East Jerusalem and the Gaza Strip. This rule represents an absolute political and humanitarian priority and an element of stability in the region. We have therefore called on international key actors as a matter of principled position and respect for the United Nations Charter and human rights to pressure Israel, the occupying power, into revoking its illegal legislation, and invited all states to provide UNRWA with additional political, legal, and financial support. We therefore hope that the advisory opinion you are about to issue will lead to compelling Israel, the occupying power, to rescind its legislation against UNRWA and represent an opportunity to reiterate under your authority the imperative duty incumbent on Israel, the occupying power, to stop the war waged against the Gaza Strip, put an end to the occupation of Palestinian territory that has dragged on for too long, and make reparation for all their consequences. Now, our Counsel, Madame Chimlier Gendro, to whom I would ask you, Mr. President, to give the floor, will develop certain legal aspects relating to the question put to you. Thank you for your attention.
Ambassadeur Bakoud, je donne maintenant la parole à la professeure Monique Chimlier-Gendro.
Mr. President, members of the court, it is an honor for me to appear before you on behalf of the Organisation of Islamic Cooperation. However, this honor is mixed with the oppressive feeling that none of us here can set aside our humanity, because that which we are to discuss in relation to the situation in the occupied Palestinian territory is, to use the expression of the representative of the United Nations Office for the Coordination of Humanitarian Affairs, and I quote, a vicious cycle of blood, pain, and death, end quote. Thus, throughout this presentation, I will remain closely in thought with the victims of the 7th of October 2023 massacres, as well as with the incommensurately more numerous victims that are the Palestinians of the West Bank, of Jerusalem, and far more still of Gaza. They are the victims and martyrs of a vengeful war. The question put to you by the United Nations General Assembly will bring me first to draw up the tally of Israel's breaches of international law. I will then show how examination of these breaches highlights questions of legal standard and legal norms. That is to say, how compliance with obligations by some lead to rights for others. The two go hand in hand. Yet, by infringing upon its obligations, Israel is impairing the rights of a people to the point that it is programming the death of that people. The whole system of the United Nations relies on actors keeping their word, pacta sunt servanda. These few words, stated in the Convention on the Law of Treaties, are the fragile foundation of this whole edifice. And relying on the honor of states for them to fulfill their commitments, the world has equipped itself with a very elaborate corpus of rules of law. Yet, the situation about which your opinion is requested to use the expression used here by other participants, is a deluge of breaches by Israel of its international commitments. This is how the illegal measures through which the Knesset has decided to close UNRWA's offices are merely the end point of a long series of previous breaches. In and of themselves, they pave the way for further, even more serious breaches. Let us now specify these three phases in Israel's infringements of international law. The first phase started with the creation of Israel. In claiming the right to undertake the measures under consideration here, Israel is infringing upon its original commitments. As a candidate state to the United Nations in 1949 already, Israel was already suspected of lacking sincerity in its international commitments. That is why the General Assembly demanded that this state, before its accession, provide the guarantee that it would abide by the Charter and all the obligations flowing from it. But the assurances provided by the representative of Israel in order for his state to accede to the organization soon proved to be fallacious. The conquest by force of a significant part of the Palestinian territory in 1949, the renewed occupation, once again by force, of the entirety of that territory in 1967, the proclamation of Jerusalem as capital of the Israeli state, the denial of the right of return for Palestinians chased from their homes, the accelerated settlement of the entire Palestinian territory. These are all expressions of disregard for all the provisions of international law. And since 1967, Israel's obstination to refuse the application of the rights of self-determination of peoples to the benefit of the Palestinian people, its indifference to all rules of humanitarian law in cases of armed conflicts and to all human rights norms, all these form a fertile ground for repeated infringements of shared norms. The latest poisonous manifestation of these will be the object of our scrutiny here. The second phase of Israel's breaches of international law is constituted by the measures taken vis-à-vis United Nations organs on the basis of an already illegal occupation. The laws voted by the Knesset on the 28th of October 2024 to put an end to UNRWA activities in the occupied Palestinian territory, and the decision that those laws should come into force as early as the 28th of January 2025 are unlawful. The same goes for the unilateral termination on the 3rd of November 2024 of the exchange of letters signed in Jerusalem on the 14th of June 1967 between Israel and UNRWA. All these decisions are indeed violations to Articles 2, Paragraph 5 and 105 of the Charter of the United Nations, which oblige Israel to assist the organization in all its actions and to grant its agents all the privileges and immunities required for the accomplishment of their functions. And to the contrary of what has been purported here by some delegations, Article 2, Paragraph 5 of the Charter cannot be interpreted restrictively, and the assistance of states is required for all actions of all organs of the United Nations and as a consequence of UNRWA. Measures taken by Israel against that organ are also a breach of the provisions of the 1946 Convention on the Privileges and Immunities of the United Nations. In withdrawing the specific agreement made with UNRWA in 1967, Israel is in breach of its obligation to begin prior negotiations before calling any agreement into question. And at the same time, this termination of a bilateral agreement has no effect in substance because Israel remains bound by the 1946 Convention to which it is a state party. The documents established by the United Nations, referred to here by several participants, have highlighted how Israel has set itself against UNRWA personnel. Many have been killed, some thrown into mass graves, others tortured while detained. The convoys carrying relief personnel and supplies have been impeded. Vital missions were targeted. Goods and supplies were damaged. Those that were imported were illegally taxed. Healthcare and education centers have been attacked. UNRWA staff or personnel has been threatened with criminal prosecution. All of this is on file, and I will not go into the detail of it. Each of these actions is an infringement of the obligations brought about under the 1946 Convention. That convention obliges signatory states to protect the personnel of the United Nations and to grant it the privileges and immunities necessary to their function, and in particular to their free movement, to grant them immunity from every form of legal process, to protect their premises and archives, and to exempt them from taxes. In an opinion dating back to 1962, you have recalled how the way in which subsidiary organs are used depend on the consent of the concerned state. And Israel, in the written statements it has presented, declares itself to be the host country of UNRWA and claims for this reason to be able to withdraw its consent to the continued presence of that agency in Jerusalem. That is an abuse of the text. There is only one country that is host of UNRWA. It is Palestine, recognized as a state by the General Assembly of the United Nations. Israel has no title, neither to host in or ban from the Palestinian territory any organ of the United Nations, because Israel's presence there is illegal according to the conclusions of your 2024 opinion. This occupation is illegal throughout the entire occupied Palestinian territory. Thus, in the West Bank, sovereignty is not in abeyance, as you recalled earlier, as Israel claims. The matter is clearly settled. Sovereignty there belongs to the Palestinian people. It is therefore not for UNRWA to depart, and especially not from Jerusalem, where Israel has no valid title under international law. It is instead Israel which should cease to illegally occupy those places.
The third stage of Israel's breach of its international obligations is to be found in the consequences of the illegal measures adopted against UN bodies. The measures in and of themselves illegal produce a cascade of unlawful effects. Indeed, again, according to your your advisory opinion in 2024, Israel, which is the illegal occupying force of the Palestinian territory, is not released from its duties as occupying power. Bound by the Fourth Geneva Convention of August 12, 1949, and the Protocols of 1977, Israel is obliged to protect the Palestinian people, to put the wounded and the civilians out of harm's way, to protect the hospitals and hospital staff and convoys transporting the wounded and the sick, to ensure the health care and education of the children, to ensure that the population is supplied in food and medicine. And when the population of an occupied territory is insufficiently supplied, to accept the relief efforts offered to the benefit of this population. We have cited the sources of these obligations in our written statement. I shall not repeat them here. Israel is in breach of all of these obligations. Now I would like to address what is at stake with the measures that are being challenged. The violations by Israel of its obligations in the occupied Palestinian territory have tragic consequences. The presence of UNRWA and the activities of the agency in the service of Palestinian refugees that are the overwhelming majority of the population of Gaza, had made it possible up until now, to avoid this population being decimated. What we are now seeing is with the prohibition imposed on UNRWA to carry on with its missions is the consequences of the transgressions that the illegal occupant is inflicting on the rights of Palestinians. Proclaimed rights are always abstract. They only become concrete in the relations between subjects of law. And with the massive breaches of all its obligations by Israel comes the denial of rights, in fact, of all the rights of the Palestinians. And this High Court expressed its concern in this regard with the 3 orders issued indicating interim measures in South Africa against Israel for the non-compliance with the Convention on the Prevention and the Punishment of the Crime of Genocide. The court alerted to the plight of the people of Gaza who were being starved, killed in vast numbers, deprived of the basic minimum needed to survive. On June 26, 2024, you ordered Israel to take immediate measures in order to ensure basic services. On March 28, 2024, in light of the confirmed starvation in Gaza, you ordered emergency measures to supply basic goods in close cooperation with the UN. And on May 24, 2024, you demanded that an end be put to the military offensive as it creates for the Palestinians in Gaza living conditions such that they could result in its physical destruction in whole or in part. We see what the response of Israel has been to your orders. There will be no end to the suffering of the Palestinian people because the body of the United Nations that was attempting, in conditions close to hell, to remedy the shortages caused by and the abuses perpetrated by the occupying power is no longer able to carry on. What we have today then is an illegal occupation by Israel that deprives the Palestinians, particularly in Gaza, of all of their rights. The rights that are recognized either collectively or individually as being rights for all human beings. The right that is completely fading out of view for the Palestinian people is the political right of self-determination. This lofty right is the right that allows a people to accomplish its destiny freely and now has been made impossible in every way. How can we speak of territorial integrity for a people when another state is occupying all points of its territory? What is left of national unity for Palestinians who are banned from assembly or coming together as a group? What meaning does the expression economic, social, and cultural development have, the very foundation of the right to self-determination for families that are dying under the bombs and whose starving survivors have neither drinking water, food, or care? And how can we speak without making a mockery of it, talk of sovereignty over natural resources in Gaza when it is being reduced to rubble? Thus, deprived of their political right, the right that it sits at the top of all rights, the Palestinians have seen all of their ordinary human rights gradually disappear. Gone is the right to freedom of movement, the right to work, the right to educate one's children, to health. Gone is the right to life. What was left was the solidarity shown by other humans, those of the international organizations, primarily UNRWA, and all those NGOs that work motivated by a feeling of humanity. The right to be aided, to get relief, the ultimate right, the last step before the final fall for those who are in dire distress. This right has been wiped out by Israel's decision to prohibit UNRWA's activities and to render impossible the intervention of other organizations. These are the facts upon which this court is called to render an advisory opinion, and this opinion will be compelling. The court can only conclude that in application of Geneva Conventions, it is incumbent on the occupying power to act in the interest of the population of the occupied territory. If it fails to do so, then it is Article 59, the Fourth Geneva Convention, that imposes this. It must accept and facilitate relief operations. Nor can it impede the work of agencies that are ensuring the protection and the survival of this population. It will be up to you to forcefully assert the ultimate right that is the right to relief, to identify this right and to characterize it. You will recognize that this right belongs to those rights that are jus cogens, because it is the key that opens the way to all the rights in this same category. And the State of Israel will have to give in, understanding that defending this right is the universal guarantee that is indispensable for all. None of us can know for sure that we will never have to face barbarism ourselves, and that we might be in desperate need of help from those whose avowed mission is to provide relief. You will be called upon to examine Israel's argument, claiming the so-called absence of neutrality by UNRWA, a justification of the measures adopted by the Knesset against this UN body. You will find that the UN, alerted by Israel's accusations against certain staff members of UNRWA, commissioned an independent commission of inquiry to look into this. The report that was produced concluded that UNRWA had adopted an approach to neutrality that was more developed than that of other similar entities within the UN family or NGOs, making it possible to conclude that there was no credible grounds for Israel's allegations. So we are left with an unlawful act that has critical consequences for the 2 million Palestinians living in Gaza. But the original unlawful act is the denial of the right of self-determination. It is the act of colonial domination. This is what fuels those who would claim to build their destiny by depriving others of their freedom. The French writer Albert Camus, in his autobiographical novel called The First Man, describes the unspeakable crimes that were committed during the colonial war waged by France in Algeria. And he has his father say, his father, who was a simple, uneducated man, who had witnessed the worst abuses, and he puts it in very simple terms, and I quote him, "A man knows what he should not do." But those who do not want to renounce domination lose all humanity, paving the way to the worst crimes. Probably here we should confine ourselves to the question as posed by the General Assembly, specifically, what are Israel's obligations with regard to the presence and the activities of international organizations and other states on the occupied Palestinian territory? But these proceedings will have been for you an occasion to observe how Israel, through the acts under consideration here, are intentionally inflicting upon the group that is formed by the Palestinians to conditions of life that are calculated to bring about its physical destruction in whole or in part. We see, thus, Israel moving from an increased risk of genocide, as you had rightly warned against in your last order, to the reality of genocide, the constituent elements of which have been outlined here today. I would finish by simply referring you to the submissions of the Cooperation of Islamic Cooperation, and by asking you to demand of Israel full reparation for all the unlawful acts committed, and to add that it is incumbent upon the Assembly General of the UN and all member states to take the strongest possible measures to put an end to the untenable situation created for the Palestinian people. I thank you for your kind attention.
Thank the representatives of the Organization of Islamic Cooperation for their presentation.
I now invite the next delegation, the delegation of the African Union, to take the floor and call Ms. Haja Guldig to the podium.
Mr. President, Madam Vice President, ladies and gentlemen, members of the court. It is with a sense of gravity and solemnity that I appear before your august court on behalf of the African Union and its 55 member states. These are indeed grave times. For over a century, the Palestinian people has endured a succession of Nakbas. Today, the humanitarian situation in the occupied Palestinian territory, this situation, which was already beyond imagination, has become even more tragic, not to say apocalyptic. The French language, rich as it is unable to faithfully describe what is unfolding in this territory. Which words would be appropriate to qualify the human tragedy of an entire population which, since the end of the ceasefire, for 61 days now, has been deprived of water, food, fuel, medical assistance, and vaccines for the children, especially with 3,000 trucks loaded with humanitarian aid blocked by Israel at the entrance to Gaza? What words would be suitable to do justice to the 51,000 Palestinians, including 15,000 children, who have already lost their lives, often in dire circumstances? Even the bulldozers necessary to find the survivors have been methodically and systematically destroyed by Israel. Of the houses, shelters, and children's playgrounds in Gaza, of their dreams of peace and justice, all that is left is 50 million tons of rubble. On this last day of hearings, it is therefore important to remember why the General Assembly has asked the court, with the utmost urgency and on a priority basis, to deliver a new advisory opinion on the situation of the Palestinian people. The reason for these new proceedings, Mr. President, is that Israel has failed to abide by its legal obligations identified by the court in its advisory opinion of 2024. Worse even, Israel has redoubled its efforts to make living conditions in the occupied Palestinian territory impossible. It has decided to ignore its own obligations as an occupying power to guarantee the individual and collective human rights of Palestinians. Furthermore, it has adopted two laws dated October 28, 2024, which further exacerbate the manifold impediments that it had already created to prevent the presence and humanitarian and development activities in the occupied Palestinian territory, both in Gaza and in the West Bank, including in East Jerusalem. In order to achieve this, Israel has imposed paralyzing measures upon UNRWA, knowing that the agency, according to the words of the Secretary General of the United Nations, is the backbone of humanitarian action in the occupied Palestinian territory. All of these measures, which place aim at placing the Palestinian people in a state of total destitution and to force it to leave. The court, however, has already examined Israel's actions, which pursue the same goal, and deemed them contrary to Israel's obligations stemming from Article 49 of the Fourth Geneva Convention. Mr. President, in the face of this endless tragedy, the African Union places its trust in international law and in your court, which embodies it. In this connection, the African Union notes that the overwhelming majority of the participants to the present proceedings have spoken in favor of the court's jurisdiction and the exercise by it of its power to deliver the requested advisory opinion. The objections raised by two states, and which run counter the well-established case law of the court, have already been defeated. The African Union subscribes to this broad consensus in respect of the court's jurisdiction. Indeed, the United Nations and therefore the General Assembly hold a permanent responsibility with regard to the Palestine question, insofar as the General Assembly was the source of the partition plan of the former British mandate for Palestine into two states. As to the court, it must participate in the activities of the organization by delivering the requested advisory opinion, and it must fully exercise its jurisdiction and complement its 2024 advisory opinion. The task now incumbent on the African Union consists in focusing the discussion on the most decisive points. The African Union will do this on the basis of its own history, that of a continent whose peoples have suffered from slavery, colonization, and apartheid, as well as the denial of their human dignity and of the rights of peoples to freely pursue their economic, social, and cultural development. From this point of view, it is evident that the urgency of the present proceedings and the extreme seriousness of the humanitarian situation in the occupied Palestinian territory should not lead us to adopt, even involuntarily, a truncated vision of the scope of the rights of the Palestinian people and of the obligations of Israel at issue. Indeed, the question put by the General Assembly does not relate solely to the unimpeded provision of humanitarian assistance to the Palestinian people by third parties. More broadly, it requires the court to rule on Israel's obligations to respect the human rights of Palestinians, including the rights of the Palestinian people to their existence and not to be deprived of its means of subsistence. It also invites the court to rule on the right of the Palestinian people to economic, social, and cultural development, as well as its right to enjoy the advantages of international cooperation and solidarity. The oral statement of the African Union will be structured as follows. I will begin by clarifying the definition of Israel's obligation to provide full assistance to the United Nations in all their action in favor of the Palestinian people. I will then invite you, Mr. President, to give the floor to Professor Mamadou Ebié, who will explain Israel's obligation as the occupying power, including those pursuant to human rights and the rights of peoples. And lastly, Professor Ebié will demonstrate that the safety considerations invoked by Israel and some other states are ineffective. Mr. President, let me now turn to the examination of Israel's obligations as a member of the United Nations. A few participants have argued that a state holding grievances against a United Nations body is released both from obligations stemming from its quality of member and of the obligation to abide by the privileges and immunities of the organization. Essentially, this is the argument consisting of blaming UNRWA in order to deny it the full assistance required under Article 2, Paragraph 5 of the Charter, and to abide by its privileges and immunities. However, neither customary international law nor the United Nations Charter contain any rule allowing states to unilaterally escape obligations inherent to their quality of members of the United Nations by invoking grievances against its organizations and bodies. Indeed, these obligations are not reciprocal obligations owed to UN bodies. They are therefore not subject to the exceptio non ad impleti contractus, also called the exception of non-performance. These obligations, rather, are erga omnes partes, owed to all member states pursuant to Article 2, Paragraph 2 of the Charter. Consequently, the grievances raised by Israel with regard to UNRWA cannot release it from its obligations pursuant to the Charter and of the principle pacta sunt servanda with regard to the members of the United Nations, and the African Union will not, therefore, entertain them further. Several participants have already established, on the basis of sufficiently convincing evidence, the reason why the court should not give them any credit. However, the African Union recalls that both the Charter and the General 1946 Convention provide for remedies for settling difficulties which might arise between a member state and the organization in the implementation of the obligations stemming from these instruments. Israel must therefore avail itself of these remedies and put an end to its unilateral and arbitrary measures. Mr. President, the obligation to give the United Nations every assistance in any action it takes under Article 2, Paragraph 5 of the Charter also includes the obligation of providing full assistance to the action from the subsidiary bodies established by the General Assembly, such as UNRWA. This obligation covers both the normative action of the organization as its operational action. Any action means any action. It is therefore of little relevance that we make a distinction between action prescribed under mandatory resolutions pursuant to Article 25 of the Charter and those stemming from resolutions with the force of recommendations. Israel, therefore, is bound to waive any impediment to the action of the United Nations as carried out by UNRWA. Furthermore, it is bound to take all of the measures necessary to facilitate their accomplishment. Israel must also respect the immunities and privilege of the United Nations, of its personnel, and of its premises. Mr. President, members of the court, these remarks conclude my oral statement. I thank you for your kind attention, and I would ask you to now give the floor to Professor Mamadou Ibié. I would like to thank Professor Curtus, and I invite Mr. Mamadou Ibié to take the floor.
Mr. President, Madam Vice President, members of the court, it is a great honor for me to appear before you today on behalf of my continent, Africa. Today's proceedings concern one of the most pressing moral questions of our time, yet one where the voice of international law and that of the African Union remain crystal clear. Israel must respect the collective and individual rights of the Palestinians. As announced by the Legal Counsel, I will first establish that Israel's obligation as an occupying power extend beyond the law of occupation. I will then demonstrate that the security concern invoked by Israel cannot affect the enjoyment by the Palestinians of their human and people's rights because of the very nature of those rights. Mr. President, Israel's obligation as an occupying power go beyond those enshrined in the 1949 Geneva Convention and in the 1907 Hague Regulation. Indeed, the corpus of the law of occupation has evolved significantly since the conclusion of this instrument. A case in point, in 1907 or in 1949, the right of peoples to self-determination and the host of associated rights had not yet crystallized under customary international law. The twin international covenants were not yet adopted. Moreover, the notion that an occupying power owes rights to the population of the occupied territory had not yet entered common legal consciousness. Yet, it is undisputable today, as the court has found, that the international covenants and the Convention on the Rights of the Child impose legal obligations on Israel in the occupied Palestinian territory. It is equally indisputable that Israel is subject to the obligation to respect the Palestinian people's right to existence, to self-determination, and to economic, social, and cultural development. Accordingly, Israel's obligation under the Hague Regulation and the Fourth Geneva Convention must be interpreted and applied within the framework of the entire corpus of international law prevailing today, in accordance with the court statement in the Namibia advisory opinion. This is not novelty. The court has already applied this technique of interpretation and application of international law in the Diallo case. To recall, the court observed that, and I quote, owing to the substantive development of international law over recent decades in respect of the rights it accords individuals, the scope ratione materiae of diplomatic protection, originally limited to alleged violation of the minimum standard of treatment of aliens, has subsequently widened to include inter alia internationally guaranteed human rights. The African Union therefore submits that, owing to the substantive development of international law over recent decades, in respect of the rights that it accords to individuals, the scope ratione materiae of the obligation of occupying powers, while framed originally in terms of basic and essential needs of the population concerned, has subsequently widened to include internationally guaranteed human and people's rights. Mr. President, this application of the law of occupation within the framework of the entire corpus of contemporary international law entails several consequences. First, Israel must not simply provide the Palestinians with necessary foodstuff. It must respect their right to food. It must ensure effective enjoyment by the Palestinian people of its right to existence and not to be deprived of the means of its subsistence under any circumstance. Secondly, Israel must not simply agree to relief schemes by third states and international organizations. It has no power to decide. Instead, Israel must respect the Palestinian people's right to engage in international relations and to enjoy the benefits of international cooperation and solidarity. Thirdly, Israel must not simply ensure public health and hygiene in the OPT. Instead, it must ensure the effective enjoyment by the Palestinians of their right to health. Fourthly, Israel must not only comply with the few provisions on education that we find in the Fourth Geneva Convention. It must fully respect all the rights of Palestinian children, including their right to education. Finally, Israel must not, and it has no right, to administer the OPT or to do it as a usufructuary. To recall, Israel's occupation of the OPT is unlawful, and the court has requested Israel to bring it to an end as rapidly as possible. Rather, Israel must guarantee the effective enjoyment by the Palestinian people of its right to self-determination, and pending the termination of its occupation, respect the Palestinian people's right to economic, social, and cultural development. Occupation, Mr. President, cannot serve as a ploy to deprive the Palestinian people of the effective enjoyment of its right and to keep it, to use the words of this very court, in a state of suspension and uncertainty. The fact that Israel has no title to administer the OPT does not release it from, nor does it reduce its obligations and responsibility under international law towards the Palestinian people and other states in respect of the exercise of powers in the OPT. Mr. President, please allow me to briefly elaborate on the importance of the right of the Palestinian people to maintain international relations with third states and international organizations without impediment. Let's look back at history. If slavery lasted for 4 centuries, if colonialism persisted for 2 centuries, if apartheid lasted for 5 decades, it was because those states that engage in these practices benefited from the silence and the lack of decisive action by third states. This is why contemporary international law not only grants rights, but imposes obligations on third states and international organizations to cooperate and provide assistance for the effective enjoyment by peoples of their rights. Israel cannot put the Palestinian people in a predicament where its very existence and its right to economic, social, and cultural development are constantly in question and push or force away the international community. As an occupying power, it must remove all impediment to the conduct by third states and international organizations of diplomatic relations with the Palestinian people and facilitate all actions to support them in the enjoyment of their individual and collective rights. Mr. President, I now move to the Security Council, to the security concerns that are alleged by Israel, and here I will be very brief. The very nature of the rights that I just mentioned make it impossible for an occupying power to justify restrictions. It is impossible to condition the right of a people to existence, its right not to be deprived of its means of subsistence, its right to self-determination, or to economic, social, and cultural.
Gomez Robledo and Cleveland. The written text of these questions will be transmitted to the relevant participants by the registrar as soon as possible.